Before we begin, a quick and important disclaimer. The historical trends, legal frameworks, societal observations, and case studies discussed in this documentary regarding divorce, family law, asset division, and marital contracts are intended strictly for educational and entertainment purposes. Family law is a highly complex, constantly evolving field that varies drastically by state, county, and jurisdiction within the United States. The information provided in this presentation does not constitute formal legal, financial, tax, or psychological advice. Navigating a separation or divorce involves highly individualized and deeply complex circumstances that require the direct expertise of licensed family law attorneys, certified financial planners, forensic accountants, and mental health professionals. State statutes regarding alimony, child custody, equitable distribution, and community property are subject to change. Always conduct your own rigorous due diligence and consult with qualified, licensed experts in your specific jurisdiction before making any decisions that could impact your legal standing, financial security, parental rights, or personal well-being. In 1969, with the simple stroke of a pen, California Governor Ronald Reagan quietly triggered the greatest transfer of wealth, the most profound demographic shift, and the largest restructuring of the American family in the history of the Republic. By signing the Family Law Act, California became the first state in the Western world to institute no-fault divorce. It was a seemingly progressive piece of legislation designed to free individuals from toxic, abusive, or simply loveless marriages without forcing them to drag their darkest domestic secrets into a public courtroom. But what began as a legal pressure valve to safely dissolve broken homes rapidly mutated into a massive, unstoppable societal contagion that fundamentally rewrote the social contract of the United States. Within a single decade, almost every other state in the Union scrambled to adopt similar legislation, and the foundational bedrock of American society permanently fractured. To understand the sheer magnitude of this transformation, you have to look at the deeply hidden mechanics of what marriage used to be. Prior to this legislative revolution, obtaining a divorce in the United States was a grueling, adversarial legal battlefield. You could not simply decide you were unhappy and walk away. You had to prove legal fault. You had to prove adultery, abandonment, extreme physical cruelty, or felony conviction. The legal barriers were purposefully designed to be incredibly high to protect the institution of marriage for the sake of social stability and child-rearing. In states like New York, the laws were so incredibly restrictive that an entire underground economy emerged. Desperate spouses would literally hire private investigators and paid actors to stage fake scenes of infidelity in cheap motel rooms, complete with hired photographers bursting through the door to capture the fabricated evidence required by the strict legal standards of the time. It was a humiliating, expensive, and deeply shameful process. But when the no-fault floodgates opened, the stigma vanished almost overnight, and the statistics that followed were nothing short of catastrophic. In the 1950s, the concept of divorce was a societal anomaly. By the early 1980s, the American divorce rate had skyrocketed to an unprecedented historical peak, cementing the terrifying and widely repeated statistic that half of all marriages are destined to end in the courtroom. We watched the creation of an entirely new economic engine, the divorce industry. What used to be a private family tragedy was swiftly commodified into a $50 billion a year domestic behemoth. This industry is powered by an army of family court judges, aggressive litigators, professional mediators, forensic accountants, and court-appointed custody evaluators. It is a massive economic machine that thrives entirely on human conflict, and it is a machine that starves if a couple decides to part ways amicably. Yet, the true shock lies in what is happening right now, in the present day. The traditional narrative that half of all marriages fail is actually becoming dangerously outdated, but the reality replacing it is far more alarming. Today, the divorce rate in the United States is technically dropping, but it is dropping for a deeply unsettling reason. The working and middle classes of America are simply abandoning the institution of marriage altogether. Marriage is rapidly transforming from a universal societal baseline into an exclusive luxury good, reserved primarily for the highly educated and the wealthy as a calculated mechanism for asset preservation. Meanwhile, a silent, devastating epidemic known as gray divorce is currently sweeping through the baby boomer generation. Couples over the age of 50 are dissolving their marriages at a rate that has doubled since the 1990s, systematically vaporizing decades of accumulated wealth, forcing the liquidation of hard-earned retirement accounts, destroying generational home equity, and creating a massive new demographic of financially destitute seniors facing their twilight years in total economic isolation. How did we arrive at this critical juncture? How did an ancient institution explicitly designed to ensure generational stability, pool economic resources, and protect vulnerable children morph into a high-stakes, weaponized legal contract with a terrifyingly high historical failure rate? More importantly, what are the hidden legal and financial mechanics that operate behind the closed doors of family court, dictating who walks away with their life intact and who is left entirely ruined? There is a secret, sophisticated architecture to the American divorce industry, a complex web of legal precedents, financial incentives, and historical accidents that the average citizen is completely blind to until the very moment they are served with legal papers. In this exhaustive step-by-step masterclass, we are going to meticulously dissect the complete transformation of divorce in U.S. society. We are going beyond the surface-level statistics and emotional platitudes. We will map out the precise historical trends that eroded the traditional marriage contract and the specific legislative milestones that constructed the modern family court system. You will be exposed to the devastating, yet highly predictable financial outcomes that define the dissolution of a modern partnership. We will analyze detailed historical trends and deeply researched case studies to reveal the psychological engineering behind marital breakdown, the aggressive weaponization of child custody, and the brutal, unforgiving reality of asset division in the 21st century. We will explore how courts calculate the present value of future pensions, how hidden assets are traced through corporate shells, and how the concept of lifelong alimony has been systematically dismantled and replaced by rehabilitative support. For the unmarried, this presentation will serve as the ultimate, indispensable risk assessment framework before entering into a legally binding union. For the married, this is an unflinching roadmap to the hidden vulnerabilities and legal tripwires that currently exist within your own household. And for those currently navigating the exhausting gauntlet of the family court system, this deep dive will illuminate the underlying machinery of the adversarial process you are currently trapped inside. You are about to understand the business of broken homes, the economics of heartbreak, and the stark reality of what it truly means to unravel the American family. To truly comprehend this unraveling, we must first shatter the most pervasive myth surrounding modern separation. Society conditions us to believe that ending a marriage is a purely emotional event, a tragic but ultimately liberating untangling of two incompatible hearts. But the moment a petition for dissolution is filed at the county courthouse, the emotional reality is instantly stripped away, and the marriage is violently reclassified by the state. In the eyes of the law, a marriage is not a romance. It is a highly complex, deeply entrenched financial corporation, and a divorce is simply the hostile liquidation of that corporation. Imagine if you entered into a binding corporate partnership, commingled every single dollar you earned, co-signed massive debt obligations, and agreed to split the future profits of your labor for the rest of your life, all without ever writing down a formal exit strategy. That is precisely what a standard marriage license represents in the United States today. When that unwritten exit strategy is suddenly forced into existence by a judge, the resulting financial shockwave is absolute and uncompromising. Let us examine a highly realistic case study grounded in the current economic landscape of 2026. Consider David and Emily, a typical middle-class couple living in a suburban neighborhood in Pennsylvania. After 14 years of marriage, they have accumulated what looks like a comfortable life. They have a house currently valued at $500,000, secured with a historically low 3% mortgage rate from several years ago. They have roughly $300,000 saved across 2 retirement accounts, 2 cars, and $30,000 in credit card debt. On paper, they have a combined net worth of roughly $500,000. When Emily files for divorce, they both naively assume they will simply sell the house, split the retirement funds down the middle, pay off the debt, and walk away with $250,000 each to start their new lives. This is the illusion of the 50-50 split, and it is the exact moment the massive divorce industry steps in to extract its toll. The second the legal machinery is activated, an invisible meter begins running. The first realization David and Emily face is the staggering cost of simply entering the arena. In 2026, the average initial retainer for a competent family law attorney in a contested divorce ranges from $10,000 to $25,000 per person. Instantly, $50,000 of their household liquidity is locked up just to initiate the legal conversation. But the retainer is not a flat fee. It is essentially a prepaid debit card that their attorneys will bill against at a rate of $400 to $600 an hour. Every email sent, every phone call answered, every legal precedent researched, and every document reviewed is meticulously tracked in 6-minute increments and deducted directly from that retainer. Once the attorneys are officially retained, the couple enters the most exhausting, invasive, and financially destructive stage of the process known as discovery. Discovery is the legal mechanism where both parties are compelled by the court to lay bare every single aspect of their financial existence. It is nothing short of a total financial autopsy. David and Emily will be subjected to interrogatories, which are exhaustive lists of written questions they must answer under the penalty of perjury. They will face aggressive requests for production of documents, requiring them to unearth and submit 5 to 10 years of bank statements, tax returns, credit card bills, mortgage documents, and retirement account ledgers. If either party suspects the other of hiding money, the complexity and the financial burn rate multiply exponentially. This is when the forensic accountants are subpoenaed into the fray. A forensic accountant is a highly specialized financial detective who will charge upwards of $500 an hour to forensically trace every dollar that flowed through the marital estate. They will look for minute discrepancies in tax filings, unearth hidden shell companies, search for undisclosed cryptocurrency wallets, and analyze lifestyle spending to determine if marital funds were illegally siphoned off. In our case study, David and Emily might easily burn through another $40,000 solely in forensic accounting fees during a contested discovery phase. As the months drag into years, the couple realizes another devastating truth about modern property division. The United States is fundamentally divided into two distinct legal frameworks when it comes to divorce: community property states and equitable distribution states. In the 9 community property states, which include massive populations in California and Texas, the law generally dictates a strict 50-50 split of all assets and debts acquired during the marriage, regardless of who earned what. But in the remaining 41 equitable distribution states, the courts operate under a completely different mandate. Equitable does not mean equal. It means fair, and fair is a highly subjective term decided entirely by a single-family court judge. In an equitable distribution state, the judge will analyze a massive array of factors. They will look at the exact length of the marriage, the age and physical health of both parties, their respective earning capacities, their established standard of living, and the unique contributions of each spouse, including the deeply subjective value of the unseen contributions of a stay-at-home parent. This immense judicial discretion creates massive unpredictability. David might argue that he should receive a significantly larger share of the retirement accounts because he was the primary breadwinner, while Emily might successfully argue that her career suffered irrecoverable damage because she stayed home to raise their children for 5 critical years. This legal ambiguity ensures that the fight over the assets will be bitter, protracted, and incredibly expensive to litigate. And then comes the devastating reality of the marital home in the current economic climate. The house is almost always the largest physical asset, and it frequently becomes a toxic financial trap. Because they locked in a 3% mortgage rate years ago, neither David nor Emily can afford to buy the other out and refinance the home at the current, significantly higher interest rates of 2026. The only logical option is to force the sale of the property. By the time they pay the standard real estate agent commissions, closing costs, and potential capital gains taxes, the equity they thought they had is severely diminished. When the dust finally settles after 2 years of brutal litigation, the attorneys are paid, the forensic accountants are paid, the mediators are paid, and the state has taken its share. The $250,000 David and Emily each expected to easily walk away with has been reduced to a fraction of its original value, leaving them both financially crippled as they attempt to re-enter a brutal housing market as single adults. This is the baseline financial devastation of a standard, middle-class divorce. But what happens when the financial battleground is no longer just about retirement accounts, mortgage rates, and credit card debt? What happens when one spouse realizes that the ultimate leverage in a hostile divorce negotiation is not a bank account, but the children themselves? The financial liquidation of a marriage is brutal, but the true nightmare begins when the courtroom turns its full attention to child custody, transforming human lives into strategic bargaining chips in a psychological war that will permanently alter the future of the next generation. The modern child custody battle is, without exaggeration, the most destructive theater of the American family court system. To understand why this process systematically destroys families, you must first examine the historical trends that created the modern legal framework. For much of the 20th century, the United States operated under what was known as the tender years doctrine. This was a legal presumption that during a child's formative years, mothers were inherently uniquely equipped to provide care, and fathers were generally relegated to the role of financial providers with alternating weekend visitation. The courts rarely deviated from this rigid formula. But as societal roles evolved and constitutional challenges mounted, the tender years doctrine was entirely dismantled. In its place, the courts adopted a new gender-neutral standard that governs every single custody case today: the best interests of the child. On the surface, prioritizing the best interests of a child sounds entirely rational and undeniably moral. However, in the unforgiving machinery of family law, this standard is essentially a blank check for infinite litigation. Because the concept of best interests is not a mathematical equation, it is deeply subjective. It requires a family court judge, who has never met your children, to peer into your life and determine which household environment is superior. This monumental ambiguity forces parents to aggressively prove their own virtue, while simultaneously documenting the flaws, failures, and psychological shortcomings of their former partner. The system mathematically demands character assassination. Let us look at a highly typical case study unfolding right now in 2026. Imagine if Michael and Sarah, a couple residing in Ohio, decide to divorce after 10 years of marriage. They have 2 children, aged 7 and 9. Both Michael and Sarah are deeply involved, loving, and highly competent parents. In a rational world, they would seamlessly transition to a shared parenting arrangement. But they are quickly informed by their respective legal counsel that physical custody is directly and permanently tethered to the state child support grid. In almost every jurisdiction, the amount of child support one parent pays to the other is calculated through an income shares model, heavily weighted by the exact number of overnight stays each parent secures. If Michael accepts a traditional schedule of every other weekend and 1 dinner a week, he will possess roughly 20% of the parenting time. Consequently, he will be ordered to pay maximum child support to Sarah for the next decade. However, if Michael fights for and wins a 50-50 equal parenting schedule, his child support obligation could be drastically reduced or entirely eliminated. This creates a terrifying financial incentive structure. Custody is no longer just a desperate plea for time with one's children. It is secretly a high-stakes battle over long-term, tax-free capital transfer. When hundreds of thousands of dollars in future child support payments are directly tied to the custody ledger, amicable agreements frequently disintegrate, and the psychological warfare officially begins. Because the judge cannot possibly know who the better parent is, they will frequently outsource the decision to a private industry of court-appointed experts. Michael and Sarah will be ordered to undergo a comprehensive forensic custody evaluation. This is not a casual interview. It is a grueling, hyper-invasive, and phenomenally expensive process that can take up to a year to complete, costing the couple an average of $15,000 to $30,000 out of pocket. The evaluator, usually a clinical psychologist, will subject both parents to exhaustive psychological testing. They will administer standard diagnostic tools like the Minnesota Multiphasic Personality Inventory, designed to detect hidden pathologies, depression, anxiety, and personality disorders. The deep tragedy here is that anyone enduring the trauma of a hostile divorce will naturally register high levels of anxiety and depression, but in the sterile environment of a clinical evaluation, these natural human reactions are routinely pathologized and weaponized against them. The evaluator will conduct extensive clinical interviews, deeply probing into the couple's sex life, their arguments, their financial disagreements, and their childhood traumas. They will execute unannounced home visits to inspect the contents of refrigerators, the cleanliness of bedrooms, and the safety protocols of each residence. They will interview collateral contacts, interrogating the children's school teachers, pediatricians, neighbors, and even extended family members. The children themselves will be interviewed in private, placed in the impossible position of navigating their parents' unspoken anxieties. The final product of this exhaustive investigation is a massive, highly detailed psychological report submitted to the judge, containing strict recommendations on who should receive primary custody. Judges, lacking psychological training and operating under crushing caseloads, will almost always rubber stamp the evaluator's findings, turning the opinion of one hired professional into the unalterable law of the family. While this year-long investigation grinds forward, the couple falls into the most dangerous legal trap of the entire process: the temporary order. Because children need immediate stability while a divorce is pending, courts establish temporary custody schedules within the first few weeks of filing. Often, these orders are decided in brief, 15-minute hearings based on rushed affidavits. If Sarah successfully argues that she has historically handled the majority of doctor appointments and school drop-offs, The judge will likely grant her primary temporary custody to maintain the status quo. This status quo bias is the silent killer of shared parenting. Courts are fundamentally terrified of disrupting a child's routine. If Sarah holds primary custody for 12 months while the forensic evaluation is slowly completed, she gains an almost insurmountable legal advantage. Even if Michael proves he is a perfectly capable parent, the judge will look at the past year, observe that the children are surviving under the temporary arrangement, and refuse to alter the schedule. The temporary order essentially becomes the permanent reality by sheer default of time. This dynamic triggers a vicious race to the courthouse, where both parents are advised to fiercely guard their parenting time, refuse compromise, and establish dominance in the physical schedule before the judge ever strikes the gavel. But what happens when the standard evaluations, the financial maneuvering, and the battle over the status quo are simply not enough to secure victory? What happens when the stakes are so high, and the hatred so profound, that one party decides to bypass the lengthy evaluation process entirely and deploy the ultimate nuclear weapon of the family court system? A tactical maneuver so devastating, so completely immune to standard legal defense, that it instantly strips a parent of their constitutional rights, severs their access to their children, and forcibly evicts them from their own home within a matter of hours, all based on a single unverified piece of paper. That piece of paper is known as an ex parte temporary restraining order, and within the dark corridors of modern family law, it is frequently and chillingly referred to as the silver bullet strategy. To comprehend the sheer destructive power of this legal maneuver, you must understand the fundamental constitutional override it represents. In almost every other area of American jurisprudence, you possess the absolute right to due process. You have the right to face your accuser, review the evidence against you, and present a defense before the state can strip you of your property, your liberty, or your family. But in the highly volatile realm of domestic relations, this foundational constitutional protection is intentionally suspended in the name of immediate safety. The term ex parte is a Latin legal phrase meaning from one party. It signifies a judicial proceeding brought by one person in the absence of, and without representation or notification of, the other party. Historically, these emergency orders were designed as vital life-saving instruments to protect actual verified victims of imminent domestic violence from severe physical harm. However, as the divorce industry rapidly expanded and the financial stakes of child custody skyrocketed, this protective shield was swiftly reverse-engineered into a tactical weapon of mass destruction. Because the burden of proof required to obtain an ex parte order is shockingly low, it has become the most ruthlessly efficient method to instantly bypass the exhausting year-long forensic custody evaluations we previously discussed. Consider the terrifying reality of this process in the current landscape of 2026. A spouse can simply walk into a county courthouse, fill out an affidavit, and claim under oath that they feel threatened, harassed, or fearful for their safety. They do not need to provide medical records, police reports, audio recordings, or independent eyewitness testimony. In many jurisdictions, the purely subjective claim of feeling psychological distress or anticipating future harm is entirely sufficient to meet the legal threshold. A judge who is statistically terrified of dismissing a petition and risking a subsequent public tragedy that could end their judicial career will review this one-sided document behind closed doors and almost always sign the order. Imagine if Robert, a mid-level manager living in suburban Georgia, is navigating a tense but entirely non-violent separation with his wife. They are sleeping in separate bedrooms, barely speaking, but attempting to coexist while the lawyers negotiate. On a random Tuesday afternoon, Robert hears a heavy knock on his front door. He opens it to find two armed county sheriffs standing on his porch. They hand him the ex parte order. In that exact fraction of a second, his entire life is legally vaporized. He is given precisely 15 minutes to pack a single bag of clothing under the watchful eyes of law enforcement. He is ordered to surrender any legally owned firearms immediately. He is marched out of his own home, the house he pays the mortgage on, and warned that if he steps foot on the property again, he will be subjected to immediate criminal arrest and mandatory jail time. But the eviction is merely the physical manifestation of the silver bullet. The true devastation is the absolute severing of the parental bond. The temporary restraining order legally mandates zero contact. Robert cannot call his wife to ask what is happening. More importantly, he is entirely prohibited from contacting his children. He cannot pick them up from school. He cannot attend their soccer games. He cannot even send them a text message to say goodnight. If he attempts any form of communication, it is classified as a violation of a protective order, a criminal offense that will obliterate his chances of ever securing shared custody. He is instantly rendered homeless, isolated, and treated as a dangerous criminal based entirely on an untested allegation. This tactical maneuver instantly secures three massive, almost insurmountable victories for the accusing spouse. First, they gain exclusive use and possession of the marital residence without having to buy the other spouse out or negotiate a temporary financial settlement. Second, they establish an immediate court-sanctioned status quo of 100% physical custody, deeply influencing the long-term trajectory of the case. Third, they force the accused spouse into a state of total financial and psychological exhaustion. Robert is now forced to secure emergency housing, sign a short-term lease, buy new basic necessities, and simultaneously hire a specialized defense attorney to fight the protective order, draining tens of thousands of dollars from the marital estate before the actual divorce has even technically begun. The legal system dictates that Robert has the right to a return hearing to defend himself, usually scheduled within 14 to 21 days. However, in the deeply backlogged family court systems of 2026, these hearings are frequently delayed, rescheduled, or pushed back for months. During this massive gap in time, the alienation becomes entrenched. The children are left completely confused, wondering why their father suddenly vanished like a fugitive. The accusing spouse is given unmitigated time to shape the narrative, potentially coaching the children or solidifying their own absolute control over the household dynamic. When the return hearing finally takes place, the evidentiary standards are fundamentally different from a criminal trial. Robert is not presumed innocent until proven guilty beyond a reasonable doubt. Family court operates on a preponderance of the evidence, meaning the judge only has to believe that it is slightly more likely than not 51% that an incident of harassment or fear occurred. Even if Robert successfully defends himself, proves the allegations were entirely fabricated for tactical leverage, and the judge dismisses the protective order, the structural damage to his life and his custody case is already permanently cemented. The legal system rarely, if ever, penalizes the accusing spouse for filing a false or exaggerated petition. The judge will simply state that the standard of proof was not met and move on to the next case on the overwhelming docket, leaving Robert to pick up the shattered pieces of his relationship with his children. This rampant weaponization of protective orders fundamentally degrades the integrity of the entire judicial system, drawing vital resources away from legitimate victims in true danger. It creates a chilling atmosphere of sheer terror for anyone entering a contested divorce, knowing that their access to their children and their own home can be instantly terminated without a shred of initial due process. But once the brutal battles over physical territory and child custody are temporarily stabilized, the legal machinery shifts its gaze back to the underlying financial engine of the marriage. The battle over the bank accounts and the equity was just the preliminary skirmish. The true financial terror of the American divorce system lies not in dividing what you have already earned, but in the court's terrifying authority to lay claim to the money you have not even made yet. What happens when a judge decides to calculate your future worth? What happens when the court determines that you are intentionally underemployed and officially taxes you on a phantom income that does not actually exist in reality? The historical concept of lifelong alimony has been quietly dismantled and replaced by an incredibly complex, highly predatory system of financial projection that can bind a person to their former spouse's lifestyle for decades after the marriage is dead. To understand how this financial projection mechanism operates in the modern era, we must trace the legal evolution of spousal support. Historically, permanent alimony was the standard. If you were the primary breadwinner, you were expected to maintain the standard of living your spouse had grown accustomed to until death or remarriage. But as dual-income households became the cultural norm, family courts began to view permanent alimony as an outdated relic. Legislatures across the country reformed the statutes, heavily favoring what is now broadly classified as rehabilitative support or transitional maintenance. The theoretical goal was to provide a temporary financial bridge, allowing the lower-earning spouse the necessary time to acquire education, update their resume, and successfully re-enter the workforce to become self-sufficient. On paper, this sounds like a progressive, pragmatic modernization of family law. In practice, however, it has created an intricate, highly destructive mathematical trap. Family courts in 2026 utilize rigid, algorithm-based calculators to determine exact monthly spousal support payments. These formulas weigh the length of the marriage, the gross incomes of both parties, and the established marital lifestyle. Let us examine the concept of the established marital lifestyle, a deeply subjective standard that creates profound economic devastation. During a marriage, a couple pools their resources to fund a specific standard of living. This might include a large suburban home, private school tuition, premium healthcare plans, 2-vehicle leases, and annual international vacations. When the marriage ends, the court's theoretical mandate is to ensure neither party suffers a drastic, disproportionate drop in that standard of living. But this is a strict mathematical impossibility. You are taking the exact same pool of income and demanding it abruptly support two entirely separate households. You now have 2 mortgages or rent payments, 2 sets of utility bills, 2 sets of property taxes, and duplicate household expenses. The money simply does not exist to maintain the historical lifestyle. Yet, the spousal support calculators are strictly programmed to chase that impossible standard, forcing the higher earner to bleed their resources dry to prop up an economic mirage. This brings us to one of the most terrifying, yet routinely applied financial weapons in the divorce industry arsenal: the legal doctrine of imputed income. Imputed income occurs when a family court judge arbitrarily decides that you are intentionally underemployed, voluntarily earning less than your maximum potential, or purposefully deflating your income to avoid paying higher spousal support. In these scenarios, the court completely bypasses your actual paycheck. The judge will legally assign you a phantom income. This is a hypothetical salary that you do not actually earn, but that the court officially dictates you should be earning. You are then taxed and legally ordered to pay spousal support based entirely on this imaginary number. Imagine if James, a corporate logistics director based in Illinois, is navigating a contested divorce in the year 2026. For the last 5 years of his marriage, James earned $200,000 a year. But the brutal corporate grind severely impacted his physical health, leading to documented severe burnout. A year before the divorce was filed, James transitioned to a less demanding role at a smaller regional firm, earning $120,000. He made a rational, self-preserving career choice. However, during the divorce proceedings, his spouse hires a specialized forensic vocational expert. Let us drill down into exactly how this vocational evaluation operates. James is not just analyzed from afar. He is legally compelled to sit for a rigorous deposition with the opposing expert. He is subjected to a transferable skills analysis, a formal process where the expert dissects his past job descriptions, evaluates his mental stamina, and cross-references his resume with local labor market surveys. The expert completely dismisses James' medical records of stress and burnout, arguing that his pivot to a lower-paying job was not a medical necessity, but a calculated, bad-faith maneuver to artificially depress his income in anticipation of the divorce settlement. The expert then presents a glossy report to the judge, citing 5 currently open positions in James' geographic area that pay over $200,000, theoretically proving that James could easily secure one if he simply tried. The judge agrees with the vocational expert. The court officially rules that James is voluntarily underemployed. The judge imputes an additional $80,000 of phantom income to James' ledger. Suddenly, James is legally ordered to pay thousands of dollars a month in spousal support calculated against a $200,000 salary, while his actual real-world bank account only sees the deposits of his $120,000 job. If James fails to meet these massive monthly obligations, he cannot simply claim poverty. Unpaid spousal support accrues rapid interest, destroys his credit score, and triggers severe enforcement actions. These are not empty threats. Family courts possess immense, sweeping enforcement powers that transcend standard civil debt collection. If James falls behind, the court can issue an income withholding order directly to his employer, forcefully garnishing his wages before the paycheck ever reaches his bank account. They can intercept his state and federal tax refunds. They can place a heavy lien on his physical property. They can legally instruct the State Department to deny or revoke his United States passport, trapping him within the country. In extreme cases of prolonged non-payment, the judge can hold James in civil contempt, deploying county sheriffs to arrest him and place him in a local county jail until he manages to produce a lump sum purge payment to buy his own freedom. The court effectively binds James in a state of involuntary servitude to his former corporate lifestyle, punishing him with incarceration for stepping off the economic treadmill. Conversely, the doctrine of imputed income is also aggressively weaponized against the lower-earning spouse. Imagine if the supported spouse has been entirely out of the workforce for 10 years raising children. The court will frequently mandate that they become instantly self-sufficient. A vocational expert will evaluate their dormant skills, assign a hypothetical minimum wage or entry-level corporate salary to them, and the judge will deduct that phantom income from the spousal support award, regardless of whether that spouse has actually secured employment yet. The legal system forces a brutal, immediate acceleration of financial independence, completely ignoring the very real barriers of a highly competitive modern job market and the devastating gap in their resume. The system further traps individuals through the excruciating difficulty of modifying these support orders. If a catastrophic economic event occurs, such as a massive industry layoff, a severe recession, or a personal medical crisis, the support obligation does not automatically pause. The paying spouse must proactively file a formal petition for a downward modification of support. This requires reopening the litigation, retaining expensive attorneys all over again, paying new filing fees, and proving to the court that a substantial, involuntary, and permanent change in circumstances has occurred. Because family courts are perpetually backlogged, this evidentiary hearing might not take place for 8 to 12 months. During that entire waiting period, the original mathematically impossible payment schedule remains legally in effect, accumulating massive, non-dischargeable debt. By the time the judge finally hears the case and potentially lowers the obligation, the paying spouse has often been pushed to the absolute brink of total bankruptcy. The intricate architecture of spousal support is explicitly designed to ensure that the economic ghost of the marriage haunts both parties long after the emotional bond is severed. It is a system that demands historical performance in a deeply unpredictable economic reality. Yet, as devastating as phantom income and endless maintenance obligations are, they are strictly related to the money you generate after the marriage ends. What is infinitely more terrifying is what the family court system does to the wealth you painstakingly built before you even met your spouse. You might believe that the inheritance you received, the business you founded in your 20s, or the home you bought long before your wedding day are safely protected by the law. But there is a silent, almost imperceptible legal mechanism that destroys separate property, transforming your most guarded lifelong assets into common marital loot, ready to be divided by a judge who does not care how hard you work to build it. That silent, almost imperceptible legal mechanism is known as the doctrine of commingling, and it operates hand in hand with its equally devastating counterpart, transmutation. To grasp the sheer financial peril these concepts represent, you must understand the theoretical baseline of property division. In theory, the law attempts to draw a strict, protective boundary around separate property. Separate property typically includes any asset you own prior to the date of marriage, any direct inheritance you receive at any point in your life, and any specific gifts given exclusively to you by a third party. If you walk into a marriage with a fully paid-off house or a private investment account, the court is supposed to classify that as untouchable. But the family court system is a theater of aggressive financial warfare, and opposing attorneys are highly incentivized to shatter that protective boundary using the incredibly effective weapon of commingling. Commingling occurs the very second you mix a legally protected separate asset with marital funds. It is the financial equivalent of pouring a glass of pure, distilled water into a bucket of muddy river water. The moment the two liquids touch, the pure water is irreversibly contaminated. You cannot separate them again simply by looking at them. In the eyes of the family court, the burden of proof to trace that pure water back to its original source rests entirely on you, and that tracing process is often mathematically impossible and prohibitively expensive to execute. Let us observe this destruction through a highly realistic case study grounded in the current economic realities of 2026. Imagine if Thomas, a successful architect living in Florida, enters a marriage with a pristine, separate investment portfolio currently worth $400,000. He painstakingly built this portfolio over a decade before he ever met his wife. During the 5th year of their marriage, Thomas receives a modest marital bonus of $10,000 from his architectural firm. Without thinking, simply out of administrative convenience, he deposits that $10,000 marital bonus directly into his premarital investment account. He does not spend it. He just parks the money there for a few months. In that single fleeting moment of casual laziness, Thomas has severely compromised his financial fortress. When the divorce is filed 3 years later, his wife's attorney immediately subpoenas the investment account statements. They do not see a protected $400,000 separate asset. They see a commingled, tainted account. Because Thomas deposited marital funds into the separate account, and because that account has been actively buying and selling stocks, generating dividends and reinvesting capital over the last 3 years, the funds have become impossibly intertwined. The opposing counsel will forcefully argue that the entire account has been legally transmuted into marital property. To save his life savings, Thomas must now hire a forensic accountant at $500 an hour to perform a granular, dollar-by-dollar historical tracing analysis, attempting to legally separate the muddy water from the pure. If the tracing fails or if the judge decides the accounting history is simply too convoluted to be reliable, the court will classify the entire portfolio as a marital asset and award half of his life savings to his spouse. But the doctrine of commingling is practically benign compared to the aggressive wealth destruction caused by the legal concept of active appreciation. This is the exact mechanism where the American family court system heavily penalizes entrepreneurs and business owners. Imagine if you start a company entirely on your own, 5 years before your wedding day. You file the legal paperwork, you build the client base, and the business is undeniably your separate property. However, if that business grows in value during the marriage, the court makes a terrifying distinction between passive appreciation and active appreciation. Passive appreciation means the asset grew in value completely independent of your personal labor. For example, if you owned a plot of raw land before the marriage, and the local government decided to build a massive commercial center nearby, causing your land value to spike, that growth is purely passive. You did nothing to cause the increase. The court generally protects passive appreciation as your separate property. Active appreciation is an entirely different nightmare. Active appreciation means the asset grew because of your personal labor, your intellect, and your direct management during the marriage. And here is the fatal trap. In the United States, your labor during a marriage is legally classified as a marital asset. If you spend 60 hours a week running your premarital company, the court views your sweat equity as a continuous marital contribution. Consider the case of Marcus, who owns a small, thriving logistics company in Texas. On the day he gets married, a specialized business valuation expert determines his company is worth $2 million. During his 8-year marriage, Marcus works tirelessly, expanding the logistics network, securing lucrative new corporate contracts, and driving the company revenue rapidly upward. When the divorce is filed in 2026, the company is evaluated again and is now valued at $5 million. There is a $3 million increase in actual value. Because Marcus actively managed the company during the marriage, that $3 million growth is legally classified as active appreciation. It is entirely marital property. Marcus is suddenly ordered by the judge to pay his wife $1.5 million, representing her 50% share of the active growth. But Marcus does not have $1.5 million sitting in a personal checking account. His wealth is entirely tied up in the illiquid equity of the logistics company. To satisfy the crushing judgment of the family court, Marcus is faced with a series of catastrophic options. He can attempt to secure a massive, high-interest commercial loan against the business, crippling its operational cash flow and halting future growth. He can invite his ex-wife to become a hostile, voting shareholder in the company, a scenario that virtually guarantees endless corporate sabotage. Or he is forced to simply liquidate the company entirely, selling his life's work at a desperate fire sale price just to generate the cash required to pay the final divorce settlement. The very labor that built his American dream is the exact weapon the state uses to dismantle it. This terrifying reality extends directly to the marital home. Many individuals falsely believe that if their name is the only name on the property deed, the house is completely protected from the divorce. This is a monumental and frequently fatal illusion. If you buy a house prior to marriage, but you use a joint bank account to pay the monthly mortgage, you are using marital funds to pay down the principal balance of a separate asset. The court will apply complex mathematical formulas, such as the Moore-Marsden calculation utilized heavily in California, to carve out a pro rata marital interest in your premarital home. Furthermore, if your spouse simply helps renovate the kitchen, paints the exterior walls, or landscapes the backyard, they have contributed physical marital labor to a separate asset. The court will calculate the exact increase in property value caused by those specific renovations and award half of that equity to your spouse. You will literally be forced to buy out your own spouse from the house you own long before you even met them. As these brutal financial realities become apparent during the exhausting discovery phase, a deep, pervasive paranoia infects the litigation. When business owners realize their lives' work is suddenly on the chopping block, and high-net-worth individuals realize their family inheritance is being aggressively targeted through administrative commingling traps, the legal battlefield rapidly devolves into a dark, clandestine theater of financial espionage. If the court is going to take half of everything you have ever built, the immediate primal instinct is to make absolutely sure the court cannot find it. This initiates the most complex, fiercely expensive, and legally perilous phase of the modern American divorce. It is an underworld of deliberate financial obfuscation. We are no longer talking about arguing over a shared savings account or the equity in a suburban home. We are entering the highly sophisticated realm of intentional corporate shell games, phantom employees, offshore asset protection trusts, and the completely untraceable digital wilderness of cryptocurrency. What happens when millions of dollars simply vanish from the marital estate overnight? How do specialized forensic accountants hunt down decentralized ledgers and dummy corporations hidden across international borders? And what are the devastating, life-altering criminal consequences when a family court judge finally discovers that you have been actively lying under oath to conceal your wealth? The moment the reality of mandatory financial liquidation sets in, a profound psychological shift occurs within the minds of individuals facing a contested divorce. When otherwise law-abiding citizens realize that the family court system possesses the absolute authority to dissect their life savings, dismantle their businesses, and distribute half of their generational wealth to a former partner, self-preservation frequently overrides morality. This primal fear drives thousands of spouses into the dangerous, clandestine underworld of asset concealment. The historical trend is undeniable and deeply predictable. As the financial stakes of divorce have escalated, the methods used to hide capital have become aggressively sophisticated, transforming family court discovery from a routine document exchange into a high-stakes forensic manhunt. To comprehend the mechanics of this financial espionage in the year 2026, we must look at the most common and easily manipulated environment, the privately owned business. Business owners possess the ultimate mechanism for financial obfuscation because they directly control the cash flow, the payroll, and the accounting software. Imagine if William, the sole proprietor of a highly lucrative commercial landscaping firm in Arizona, realizes his marriage is rapidly deteriorating. Months before the official divorce petition is even filed, William initiates a strategy known as delayed invoicing. He contacts his largest corporate clients and strikes a quiet agreement to temporarily halt their payments. He continues to provide the landscaping services, but he intentionally leaves the massive invoices uncollected until the following calendar year. By doing this, he artificially starves his own company of revenue during the exact period the divorce courts will be analyzing his income. On paper, his business appears to be suffering a catastrophic downturn, drastically deflating its overall valuation and minimizing his projected spousal support obligations. Simultaneously, William might deploy the phantom employee strategy. He places a compliant family member, or even a completely fabricated identity, on the official company payroll. He issues regular biweekly salary checks to this ghost employee, classifying it as a legitimate business expense that further reduces the net profit of the company. In reality, those funds are quietly routed directly back to William through secondary, undisclosed bank accounts or converted into untraceable cash, reserves stored in physical safe deposit boxes. But for high net worth individuals, the strategies bypass simple accounting tricks and enter the realm of complex, multi-layered institutional shielding. In recent years, there has been a massive surge in the utilization of domestic asset protection trusts, particularly in states with highly aggressive trust laws like South Dakota or Nevada. A spouse anticipating a divorce might attempt to transfer millions of dollars in real estate, liquid capital, and stock portfolios into an irrevocable trust, legally naming a third party as the trustee. The strategic argument is that because the spouse no longer legally owns the assets, having surrendered control to the trust, those assets cannot be classified as marital property subject to division. However, the timing of these transfers is the critical legal tripwire. If the court determines the transfer was executed in close proximity to the divorce filing, it will be heavily litigated as a fraudulent conveyance, an intentional maneuver designed explicitly to defraud the marital estate. Yet, the traditional methods of hiding cash and utilizing offshore trusts have been entirely eclipsed by the ultimate black box of modern finance: cryptocurrency. The proliferation of decentralized digital assets has fundamentally broken the traditional family court discovery process. Historically, if a spouse suspected hidden wealth, their attorney would simply issue a barrage of legal subpoenas to major national banks and brokerage firms. The institutions would comply, and the paper trail would be exposed. But cryptocurrency operates on an entirely different physical and legal reality. A spouse can convert millions of dollars into Bitcoin or Monero, transfer those digital assets off the public exchanges, and store them on a cold storage hardware wallet no larger than a standard thumb drive. The access to those funds is secured by a private seed phrase, a highly specific sequence of 12 or 24 words. If the spouse simply memorizes those words, the wealth effectively vanishes from the physical world. There is no bank to subpoena, no corporate entity to pressure, and no physical vault to open. You cannot subpoena a human brain. This introduces the critical countermeasure of the modern divorce industry: the aggressive deployment of specialized forensic accountants armed with blockchain analytics. When a spouse claims poverty but the numbers simply do not align, the forensic accountant will execute a devastatingly effective strategy known as a lifestyle analysis. The accountant will subpoena every single credit card statement, utility bill, travel itinerary, and mortgage document to calculate the exact monthly cash burn rate required to sustain the couple's established lifestyle. If William claims his landscaping business only generates $60,000 a year, but the lifestyle analysis mathematically proves he is spending over $20,000 a month on luxury vehicle leases, private club memberships, and high-end dining, the forensic accountant has successfully established a massive, unexplained deficit. The money must be coming from somewhere. By proving the lifestyle exists, the expert conclusively proves the hidden wealth exists, shifting the legal burden entirely onto William to explain the discrepancy. To hunt down the cryptocurrency, forensic experts look for the fiat on-ramps. You cannot simply conjure digital assets out of thin air. At some point, traditional currency had to be used to purchase them. The experts will meticulously comb through years of standard bank statements, searching for minute, automated clearinghouse transfers or wire deposits sent to popular cryptocurrency exchanges. Once that initial thread is pulled, they utilize advanced blockchain tracking software to monitor the public ledgers, tracing the flow of digital tokens across multiple wallets and jurisdictions until they locate the current holding address. But what happens when the forensic experts successfully untangle the web, and the family court judge is presented with irrefutable proof of deliberate financial concealment? The consequences are absolute and frequently life-altering. In family court, your credibility is your single most valuable asset. The moment a judge determines you have actively lied under oath on a sworn financial affidavit, your credibility is permanently destroyed for the remainder of the litigation. Every future claim you make, whether it is regarding the value of a business, the necessity of spousal support, or even your capability as a parent in a custody dispute, will be viewed through the lens of profound judicial suspicion. The financial penalties for this deception are intentionally designed to be punitive, not just corrective. When a judge discovers a hidden asset, they do not simply divide it 50-50 as they normally would. Operating under established legal precedents, judges possess the immense discretionary power to sanction the deceitful spouse by awarding 100% of the concealed asset directly to the defrauded party. Furthermore, the court will routinely order the offending spouse to pay all of the legal fees, forensic accounting costs, and private investigator invoices that the innocent spouse incurred to uncover the fraud. Beyond the financial devastation, there is the ever-present threat of severe legal retaliation. Signing a false financial disclosure form in family court is the literal definition of felony perjury. While criminal district attorneys rarely prosecute perjury cases originating from civil family disputes due to overwhelming caseloads, the family court judge retains the immediate, unilateral power of civil contempt. If the judge orders William to immediately repatriate the funds he funneled into an offshore account or to surrender the private keys to his cryptocurrency wallet, and William refuses, the judge can hold him in direct contempt of court. William can be arrested by courtroom deputies on the spot and placed in a county jail cell indefinitely until he complies with the judicial order. The modern family court system is a brutal, unforgiving machine designed to ruthlessly penalize anyone who attempts to subvert its authority through financial manipulation. Because the standard state-imposed marriage contract is fraught with these terrifying vulnerabilities, and because the legal penalties for navigating a divorce poorly are so utterly catastrophic, millions of Americans in 2026 are actively refusing to rely on the default laws of their state. Instead, they are attempting to rewrite the fundamental rules of engagement before they ever walk down the aisle, seeking the ultimate, ironclad legal shield against the divorce industry. But what happens when the very contract designed to guarantee your total financial safety becomes the most aggressively targeted, fiercely litigated, and easily shattered piece of paper in the entire courtroom? That piece of paper is the prenuptial agreement, and the pervasive societal illusion surrounding it is currently setting up an entire generation for unprecedented financial catastrophe. Over the last decade, we have witnessed a massive cultural shift regarding marital contracts. Historical trends indicate that millennials and Generation Z, having grown up watching the brutal financial dismantling of their parents' marriages, are now demanding prenuptial agreements at record-breaking historical rates. In the year 2026, the prenup is no longer viewed as an insult. It is marketed as a pragmatic, necessary tool for modern wealth preservation. People enter family court clutching these documents, fully believing they are holding an impenetrable legal shield that completely bypasses the terrifying property division laws we have just explored. They believe they have successfully contracted their way out of the divorce industry. But the divorce industry does not surrender its jurisdiction easily. A prenuptial agreement is not a magical force field. It is simply a commercial contract, and in the sprawling arena of American family law, commercial contracts can be challenged, dissected, and entirely voided by a judge. The moment a divorce becomes contested, the opposing attorney does not simply accept the prenup and walk away. They immediately launch a full-scale forensic assault on the document itself. This creates a deeply exhausting legal scenario known as a bifurcated trial, which is essentially a massive, incredibly expensive trial before the actual divorce trial even begins. You are forced to spend hundreds of thousands of dollars just litigating whether the contract you signed a decade ago is even legally valid today. To understand how these agreements are routinely shattered, we must examine the specific legal tripwires that opposing counsel will ruthlessly target. The first and most successful attack vector is the legal concept of procedural unconscionability, which deeply analyzes the exact environment and timeline in which the document was signed. Let us look at a highly common case study. Imagine if Christopher, a successful software engineer in Seattle, presents a deeply restrictive prenuptial agreement to his fiancée, Amanda, just 5 days before their massive, highly publicized destination wedding. The caterers are paid, the non-refundable flights are booked, and the families have already arrived. Christopher tells Amanda that if she does not sign the document, the wedding is entirely canceled. Amanda, facing immense social humiliation, severe emotional distress, and massive financial sunk costs, signs the paper. 7 years later, when the marriage implodes, Christopher attempts to enforce the agreement to protect his vested tech stock. Amanda's attorney immediately files a motion to invalidate the contract based on severe situational duress and coercive control. In 2026, family court judges possess immense discretion to evaluate the psychological environment of a contract signing. The judge will look at the timeline, realize Amanda had no realistic opportunity to negotiate the terms or walk away without suffering catastrophic social and financial damage, and completely invalidate the entire agreement. Christopher thought he had an ironclad shield, but his own aggressive timing rendered the agreement legally useless, exposing his entire tech portfolio to standard equitable distribution. The second fatal vulnerability of a marital contract is the absolute requirement for total financial disclosure. When you sign a prenuptial agreement, you are legally waiving your right to claim a portion of your spouse's assets. However, under fundamental contract law, you cannot legally waive your rights to an asset if you do not know that asset exists. Therefore, a valid prenup requires a surgical, excruciatingly detailed schedule of assets attached to the back of the document. If a spouse intentionally hides a bank account, obscures the true valuation of a private business, or even accidentally forgets to list a specific piece of real estate, the opposing attorney will weaponize that omission years later. If you fail to disclose a $200,000 investment account, the judge will not simply divide that specific account. They will frequently throw out the entire prenuptial agreement because the foundational premise of the contract was based on fraudulent or incomplete data. Furthermore, the legal system demands strict procedural fairness regarding representation. If both parties do not have completely independent legal counsel during the drafting phase, the agreement is incredibly vulnerable. If Christopher offers to pay for Amanda's attorney to review the document just to speed up the process, he is creating a massive legal conflict of interest. The court wants to see that both individuals were advised by highly competent, independent lawyers who aggressively advocated for their specific interests. If one party signs the document without ever speaking to a lawyer, modern family courts will view the contract with extreme suspicion, often determining that the unrepresented party could not possibly have understood the complex legal rights they were permanently waiving. But even if the document was signed perfectly, with plenty of time, full financial disclosure, and 2 independent attorneys, there is a final terrifying legal override known as substantive unconscionability. This means the contract might have been fair on the day it was signed, but the actual real-world outcome of enforcing it decades later would be profoundly unjust. Family court judges operate as courts of equity. They possess a sweeping, overarching mandate to prevent citizens from becoming destitute wards of the state. Imagine if a couple signs a perfectly executed prenup, where the wife permanently waives her right to all future spousal support. 10 years into the marriage, she develops a severe, debilitating medical condition that permanently prevents her from working, while the husband has built a massive, multi-million-dollar corporate empire. When they divorce, the husband presents the prenup, legally demanding that he pay zero alimony. The family court judge will analyze the current reality, realize that enforcing this contract will literally force a disabled woman onto government welfare and food stamps, while her ex-husband lives in extreme luxury, and the judge will use their equitable power to strike the waiver of alimony from the contract. The state refuses to absorb the financial burden of your broken marriage if your spouse has the capital to support you, regardless of what a piece of paper signed 10 years ago dictates. When prenups fail, some couples attempt to execute postnuptial agreements after the wedding has already taken place. These are universally considered to be the most legally toxic and easily destroyed contracts in the entire legal system. The moment you say "I do," you enter into a legally binding fiduciary relationship with your spouse. You owe them the highest possible duty of good faith, fair dealing, and total transparency. Attempting to bargain against your spouse's financial interests while you are actively married to them is viewed by the courts as an inherent breach of that fiduciary duty. Postnuptial agreements are scrutinized under a legal microscope so intense that even the slightest hint of coercion, imbalance, or lack of consideration will cause a judge to immediately shred the document. The brutal reality is that there is no absolute escape hatch from the American divorce industry once you enter the system. The contracts are fragile, the litigation is financially ruinous, and the psychological warfare over children leaves permanent generational scars. But as the horrific mechanics of this system become widely understood by the general public, a terrifying new phenomenon is taking root. What happens when an entire generation of Americans analyzes this exact data, looks at the catastrophic risk-to-reward ratio of the modern family court system, and makes the collective silent decision to simply walk away from the institution of marriage altogether? We are currently standing on the precipice of a massive demographic collapse, a societal restructuring that is quietly tearing down the foundational economic engine of the United States and replacing it with something entirely unrecognizable. This societal restructuring is defined by a massive, unprecedented migration away from the legal institution of marriage, driving the United States marriage rate to its lowest point in recorded history by the year 2026. We are witnessing the rise of the permanent cohabitator. Millions of millennials and Generation Z citizens, having personally endured the financial and psychological trauma of their parents' brutal divorces, are making a calculated, risk-averse decision to simply opt out of the system. They are entering into long-term, deeply committed domestic partnerships, pooling their financial resources, purchasing real estate together, and even raising children, all while intentionally refusing to sign a state-sanctioned marriage license. The prevailing logic is simple and seemingly rational. If you never enter into the contract, you can never be subjected to the jurisdiction of the family court system. You are theoretically immune to the devastating algorithms of spousal support, the equitable distribution of your businesses, and the forensic audits of your separate property. But this perceived immunity is a catastrophic legal illusion. By attempting to completely bypass the established framework of family law, these unmarried couples are unwittingly stepping into a secondary, highly unpredictable, and equally destructive legal minefield. When an uncontracted domestic partnership implodes, the individuals do not simply walk away with exactly what they brought into the relationship. Instead, they are frequently dragged into the brutal arena of civil litigation, facing complex legal doctrines that can forcibly redistribute their wealth just as aggressively as a formal divorce proceeding. To understand the terrifying mechanics of unmarried separation, we must examine a highly realistic case study grounded in the current legal landscape. Imagine if Ryan and Jessica, a couple residing in Colorado, have been living together for 12 years. They intentionally avoided marriage to protect their respective financial autonomy. Over the course of a decade, Ryan built a highly lucrative commercial real estate portfolio solely in his name. Jessica, believing they were building a life together despite the lack of a legal document, severely reduced her own working hours to manage their shared household, coordinate renovations on Ryan's properties, and raise their 2 children. When the relationship finally collapses in 2026, Ryan demands that Jessica leave his house, operating under the assumption that because her name is not on any deed and they never married, she is entitled to absolutely nothing. Ryan is immediately hit with a devastating legal reality known as common law marriage. While the majority of the country has abolished this concept, a specific handful of states, including Colorado, Texas, and Iowa, still heavily enforce it. A common law marriage is not a lesser form of marriage. It is a legally binding union established entirely by the actions and behaviors of the couple, without any formal ceremony or signed license. If Ryan and Jessica consistently presented themselves to their community as a married couple, filed joint tax returns, referred to each other as husband and wife in social settings, or simply cohabitated with the mutual agreement to be married, the state can retroactively declare them legally wed. The moment a judge validates a common law marriage, the invisible shield vanishes. Ryan is instantly pulled deep into the exact family court system he spent 12 years trying to avoid, subjecting his entire commercial real estate portfolio to standard equitable distribution and exposing himself to massive retroactive spousal support obligations. But what if this exact scenario unfolds in a state that explicitly outlaws common law marriage, such as California or New York? Ryan might assume his assets are entirely safe. This brings us to the constructive civil mechanism commonly referred to as palimony, officially known in legal circles as a Marvin claim or an action for implied contract. Because family court lacks the legal jurisdiction to divide the assets of an unmarried couple, Jessica will hire a civil litigator to file a massive lawsuit against Ryan in standard civil court. In a civil action, Jessica's attorney will aggressively argue that an oral or implied contract existed between the couple. They will attempt to prove that Jessica provided vital domestic services, significantly contributing to the expansion of Ryan's real estate business, under the explicit, unwritten promise that Ryan would provide for her financial security in return. Civil court is a fundamentally different battleground than family court. There are no established statutory guidelines or neat mathematical formulas for support. It is an unstructured, highly adversarial environment where Jessica can sue for a massive lump sum payout or demand that the court impose a constructive trust over Ryan's physical properties, legally forcing him to hold a percentage of his assets for her benefit. The discovery process in these civil suits is phenomenally invasive. Forensic experts will tear through thousands of text messages, emails, and witness testimonies, attempting to legally reconstruct the financial intentions of a 12-year relationship. The legal fees associated with proving an implied contract in civil court routinely eclipse the cost of a standard divorce because there is no streamlined blueprint for the litigation. The physical division of shared assets outside of marriage presents another logistical nightmare. Imagine if Ryan and Jessica had pooled their funds to purchase their primary residence together, listing both of their names on the deed as joint tenants. In a traditional divorce, a family court judge has the overarching authority to evaluate the entire marital estate and order a fair buyout, or force the sale of the house while balancing other retirement accounts to compensate the displaced spouse. Unmarried couples possess no such legal safety net. To resolve a disputed co-owned property, they must file a specific lawsuit called a partition action. A partition action is a blunt, unforgiving legal instrument. The civil court judge does not care about your emotional attachment to the home, who paid for the recent kitchen remodel, or who needs the space for the children. If the parties cannot reach a private buyout agreement, the judge will simply appoint a neutral third-party receiver to seize control of the property, forcibly list it on the open market, and auction it off to the highest bidder. This frequently results in a desperate fire sale, significantly below current market value. The receiver will then deduct their own massive administrative fees, the real estate commissions, and the extensive legal costs of the partition lawsuit directly from the proceeds before distributing whatever marginal equity remains to the former partners. It is a system designed to rapidly liquidate physical assets, frequently destroying years of accumulated wealth in the process. Furthermore, the legal complexities surrounding children born outside of a formalized marriage add an excruciating layer of vulnerability. When a legally married couple has a child, the state automatically applies a presumption of paternity. The husband is immediately recognized as the legal father, possessing instant, unalienable constitutional rights to custody and visitation. For unmarried couples in 2026, this automatic presumption does not exist. If Ryan and Jessica separate, Ryan may discover that he has absolutely zero legal rights to demand physical access to his own children until he formally petitions the state to establish legal paternity. This process can drag on for months, leaving the father entirely isolated from his children, while the bureaucratic machinery grinds forward. Yet, simultaneously, the state will aggressively sue him for strict child support payments, applying the exact same unforgiving income calculation models used in standard divorce cases. We are witnessing the fragmentation of the American family structure. As millions of citizens actively bypass the traditional marriage contract out of sheer financial terror, they are replacing it with a precarious, hyper-individualized reality fraught with hidden civil liabilities and profound legal instability. The macroeconomic consequences are staggering. Society is shifting away from the stable generational pooling of resources toward a deeply divided population constantly bracing for civil litigation against their own domestic partners. The structural foundation that historically supported child rearing and long-term wealth accumulation is eroding, leaving individuals completely exposed to the whims of implied contracts and partition actions. The terrifying reality is that whether you sign the state-sponsored marriage license and subject yourself to the unpredictable authority of the family court, or you intentionally avoid the contract and expose yourself to the brutal, unstructured warfare of civil litigation, the legal system is flawlessly designed to extract immense wealth from the dissolution of your personal relationships. You are trapped between two equally destructive paradigms. But what if there is a third option? What if the ultimate solution to surviving this demographic shift is not found in fleeing the concept of commitment, but in fundamentally rewriting the very legal architecture of how two people unite their lives? How can an individual living in 2026 actually build a family, combine their resources, and secure their generational wealth while permanently neutralizing the devastating threats of the modern divorce industry? To answer this, we must look at a radical movement emerging among forward-thinking legal scholars and highly pragmatic individuals in the year 2026. The solution is not found in blindly signing a traditional marriage license, nor is it found in reckless, uncontracted cohabitation. Instead, a rapidly growing demographic is entirely abandoning the unpredictable, emotionally charged jurisdiction of family court and migrating their domestic lives into the cold, mathematically precise, and historically stable realm of corporate law. They are constructing what legal theorists are currently calling the corporate family model. To understand why this functions as the ultimate defense mechanism, we have to recognize exactly why the family court system is so inherently destructive. Family law operates primarily on the legal principle of equity, which grants a single judge immense, highly subjective discretion to decide what is fair and just in any given scenario. Corporate law, however, operates on the strict, unforgiving principle of contractual adherence. In business litigation, a civil judge does not care about your emotional state, who betrayed whom, or what seems fair in hindsight. The judge only looks at the four corners of the operating agreement. If the commercial contract dictates a specific mathematical outcome, that outcome is enforced with ruthless, predictable efficiency. By structuring a domestic partnership as a formal corporate entity, couples are actively stripping the state of its subjective equitable power over their personal lives. Let us explore a detailed theoretical case study of how this architecture is being deployed right now. Consider Alexander and Chloe, two highly educated professionals living in Massachusetts. They deeply wish to combine their lives, purchase a large piece of real estate, and raise a family, but they refuse to participate in the traditional marriage system. Instead of walking into a church or a county clerk office, they walk into a corporate law firm. They legally form a family limited liability company. This LLC officially becomes the central, isolated financial engine of their entire relationship. Alexander and Chloe do not simply merge their personal bank accounts and hope for the best. Instead, they each maintain their own entirely separate, highly fortified financial ecosystems. When they are ready to purchase their primary residence, they do not buy the house as joint tenants or tenants in common. The family LLC purchases the real estate. Alexander and Chloe then draft a highly detailed, legally binding corporate operating agreement for the LLC. This document explicitly outlines their individual capital contributions. If Alexander injects 60% of the initial capital for the down payment and Chloe injects 40%, the operating agreement mathematically locks in their precise equity shares. They then establish a joint operating account strictly for the LLC. Every month, they contribute a predetermined amount of capital into this corporate account to cover the mortgage, the property taxes, the home maintenance, and the utility bills. This is not legal commingling. It is a calculated, heavily documented corporate capital injection. The operating agreement dictates exactly what happens if one partner suddenly loses their job, specifying how long the other partner will cover the financial deficit, and explicitly stating whether that temporary coverage is legally considered a gift, or a structured corporate loan that accrues interest against their existing equity stake. The true, devastating power of the corporate family model is revealed during the dissolution of the relationship. If Alexander and Chloe decide to separate 10 years later, they do not hire aggressive family law attorneys to argue over who gets to keep the house or who deserves transitional spousal support. There is no spousal support in corporate law. There is only the clinical unwinding of a joint venture. The operating agreement already contains a pre-negotiated, legally ironclad buy-sell provision. It dictates the exact independent appraisal method that will be used to value the property. It gives one partner a specific, non-negotiable 90-day window to buy out the other's exact equity share. And if that financial transaction fails, it mandates the immediate, emotionless liquidation of the physical asset and the precise distribution of the capital based entirely on their original equity percentages. The dissolution is handled quickly, privately, and entirely outside the devastating wealth-extracting machinery of the family court system. But the defensive architecture extends far beyond shared physical real estate. To protect their pre-relationship wealth, individuals in 2026 are heavily utilizing institutional-level legal structures long before they ever meet a potential partner. They are placing their businesses, their inheritances, and their massive investment portfolios into domestic asset protection trusts. By transferring the legal ownership of these assets to a distinct, irrevocable trust, managed by an independent institutional trustee in a highly favorable jurisdiction like South Dakota, the individual legally removes the asset from their own personal balance sheet. If a common law marriage claim or a vicious civil palimony suit is eventually filed against them, the opposing counsel cannot easily attach a judicial lien to the trust because the individual being sued does not technically own the assets anymore. The wealth is entirely compartmentalized, shielded from the predatory reach of implied contracts and retroactive, equitable distribution. When it comes to the highly sensitive and deeply emotional issue of children, the corporate family model addresses the specific financial incentives that historically drive brutal custody battles. While you absolutely cannot legally contract child custody, because the state always retains ultimate, overriding jurisdiction regarding the welfare of a minor, you can proactively neutralize the financial warfare surrounding child support. Alexander and Chloe, operating under the strict guidance of specialized estate planners, establish a separate, irrevocable trust specifically designed for their children. They aggressively fund this trust during the healthy years of the relationship. The trust document contains strict fiduciary provisions ensuring that these specific funds can only be utilized for the direct, verifiable benefit of the children, such as medical care, private educational tuition, and housing costs. By proactively pre-funding the child's long-term financial needs through a locked corporate structure, they completely eliminate the primary incentive for a bitter custody war. Neither parent can strategically fight for primary physical custody simply to secure a massive, tax-free child support check to secretly subsidize their own personal lifestyle, because the money is strictly controlled by an independent trustee, not the custodial parent. The rampant financial weaponization of the American child is permanently neutralized. This structural transformation represents the ultimate paradigm shift in the history of American domestic relations. We are witnessing the death of the romanticized state-sponsored marriage and the rapid birth of the hyper-pragmatic, legally immunized joint venture. The American public has meticulously analyzed the $50 billion divorce industry, observed the catastrophic generational wealth destruction, studied the profound psychological devastation inflicted upon children, and recognized the terrifying unchecked power of the family court judge. They have collectively decided to stop playing a high-stakes legal game where the rules are rigged entirely against them. They are no longer placing their ultimate trust in the antiquated, highly vulnerable concept of till death do us part. They are placing their trust in bulletproof operating agreements, specialized institutional trustees, and the cold, unyielding predictability of commercial corporate law. The traditional family unit has not been destroyed. It has simply been aggressively privatized, heavily fortified, and permanently removed from the public sector. But as millions of citizens successfully execute this corporate exodus, actively starving the traditional family courts of their massive, required financial lifeblood, the sprawling divorce industry is not simply going to quietly accept its own economic obsolescence. A $50 billion machine will inevitably and violently fight to survive, as the state legal system desperately attempts to crack open these impenetrable corporate trusts and aggressively invalidate these private operating agreements. A terrifying new legal war is rapidly brewing on the horizon. What happens when the state decides that your private corporate family is a direct threat to the economic stability of the government itself? And exactly how will the legislative branch attempt to forcefully drag these independent, legally shielded citizens back into the crushing gears of the domestic relations machine? That is the dark, unfolding frontier of this societal collapse. And it is the ultimate battle that will determine the future of personal sovereignty and wealth preservation in the United States.